with her middle finger up and the caption, F school, F softball, F cheer, F everything. Someone saved that post and showed it to her coach, who promptly suspended Levy from the team for a year. But was that a violation of Levy's First Amendment rights? The issue has now reached the nation's highest court.
Hello everyone, this is Edward Eddie Paul Reyes, and today we are going to talk about summary judgment. We're going to talk about the fancy language, and most importantly, we're going to focus on how to get you to write an excellent response on an essay, whether it be on the bar exam or at the law school level. Now, before I do that, I just want to look at this language here, okay? Because it's very, the word I want to use is, of course, sophisticated, but also the word fancy. And I'll explain the word fancy in a bit, but let's look at this. It says, a court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact. No genuine dispute. It's like very, very fancy language. It means something. Now, in the last video where I talked about the 12b-6, the demur, right? I said, hey, look, there's the wording of the black letter law, the operation, the way it functions, right? So there's different components here. And what I do want you to focus on is both. I want you to focus on the actual content and on the way that the black letter law operates, or the issue, how the issue operates. Two different things. And right, like I said last time, if you look at the black letter law, you might be confused. You might take up a lot of time, right? So what I'm saying here is, look, let's do this. Let's understand the issue, understand the function, the operation, the objective, and then also concurrently, right, a lot of tasks. Also memorize the black letter law, okay? And I do want you to memorize this fancy term here: no genuine dispute of any material fact. Let's talk about the operation. Oh yeah, I do want the word fancy. I was in a hearing, and the judge was explaining something to one of the parties, a non-lawyer, and the judge said, okay, so she mentioned the legal term. And then she says, this is just a fancy way of saying, right? And then she described it. But yeah, I mean, in law, there's a lot of fancy terms. And you do have to, as a lawyer, you have to understand these terms. Okay. So with that said, let's go ahead and explain the parts here that we're going to go through. So we did look at the law. We'll get into this a little bit more. FRCP. Rule 56, summary judgment. I like how the black letter law is just stated there. Okay. And then we're going to look at an actual case that reached the Supreme Court. And then we're going to talk about the black letter law as it should be used at the bar exam level. Okay. So I'm not even going to mention law school, because if you're in law school, you should already be attaining like the knowledge at the bar exam level. Okay. So let's look at the rule here, and I'm gonna just read it, and I'm not gonna focus too much on the content because I'm gonna do that later. Again, for a lot of these rules, looking at examples will just be very helpful in terms of understanding the concepts. It says here, summary judgment. A party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense. See, a lot of these fancy languages kind of throws you off, right? I don't know. To me, it seems like I'm just going like this, blah 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 blah, right? But if we focus on certain key words, you guys will appreciate and comprehend these rules, on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute of any material fact, and that the movement is entitled to judgment as a matter of law. Okay. And then here it says time to file. It says, this is very important, and we're going to distinguish the 12b-6 motion from summary judgments. They're two different issues. Do they have the same objective to dismiss the case? Yes. But again, The timing is different. How does the summary judgment, let me ask you this. How does the summary judgment differ from the 12b6? Okay. Now, one of the ways that it differs is that for a summary judgment, you actually conduct, or let me rephrase that, you have the opportunity to conduct discovery. Yes, and it says here, right, for Rule 56, it says time to file a motion unless a different time is set by a local rule or the court orders otherwise. A party may file a motion for summary judgment at any time until 30 days after the close of all discovery. And this is, of course, federal rules of civil procedure. You might be in a district that has its own rules, and that's fine, right? So for the 12b6, the plaintiff does not have the opportunity to conduct discovery. Because why? Because the plaintiff will file the motion, and then the defendant right away, without filing an answer, they'll file the 12b6 motion to dismiss. So there's no discovery there. Here, for the summary judgment, we're going to assume that the defendant filed an answer, and then the plaintiff had the opportunity to conduct discovery, and maybe they even conducted discovery. Okay, so we are going to let's look at an actual case to see how this worked. What I'm going to do now is I'm going to focus our attention on a case that reached the United States Supreme Court. And I'm talking about Mahanoy versus Levy. And that was about a cheerleader, 14-year-old cheerleader, and she applied, right? She tried for the varsity cheerleader squad, and I think she applied to be on the softball team, something like that, and she was denied. Look at that, I'm using legal terms, right? She did not make the cut. I guess I don't know what the schools use, but I'm trying to be accurate. We'll look at the facts in a bit, but I'm just giving you a summary here. And then when she was off campus, she got on Snapchat, and she started throwing F-bombs, this and that. And so, of course, this is a case that involves the First Amendment, freedom of speech. And it does make reference to Tinker. Those of you who have taken the constitutional law class, you guys might remember Tinker. Okay, we are going to talk about that. I will refresh your memory, or if you have not approached that case, you'll gain comprehension here. Okay, so let's get into this. I do want to say that this case did reach the Supreme Court, but we're going to focus on the district, on the filings that occurred at the district level. So you have the district courts, the federal, right? We're talking about the federal sphere here, the district court, and then of course you go to the appellate courts, and then after that you could go to the United States Supreme Court. So think about the district court as being, if you're in California, the Superior Court of California, right? The state court. So let's get into this. Now here, the plaintiff did file for summary judgment. Many times it's the defendant. Can a plaintiff file for summary judgment? Yes. Now, I don't want to focus too much on that. I do want to focus on the rule and the operation. And I want you to gain an excellent comprehension of this issue. So let's continue. I'm going to skip through a lot of this. This is the actual motion that was filed by the plaintiffs, by Levy. And I do want to just point to this table of exhibits. The complaint was filed, answered, and remember, discovery is allowed, and it happened here. So that's going to distinguish the summary judgment from the demur. Let's continue. Okay, so I already stated some of this. High school cheerleaders. She got a Snapchat, and let's look at what she said, because this is important, right? For even if it's obscene, or right, it has these words that, right, foul language. As an attorney, you just have to rise to a level where you have to study the content in an educational, right, setting. And it's foul. It's right. It's no one wants to see this type of language, but right, as an attorney, and let me tell you, Once you get out there to practice, and right, you're gonna see, you're gonna be exposed to human, right? Some of the some awful things that humans do, but you're a professional. I just want you to keep that in mind. And of course, I'm not gonna say this because YouTube, right? They have little spiders there, and I don't know what can happen, right? But you could just read it. F school, she says. F softball. F cheer. F everything, she says. And it was on a weekend. It was off campus. And let's see, she was not involved in any school activities. So I highlighted these facts because the plaintiff is going to use these facts to make her case. And we're going to explore the issues now. Now, one thing I did not mention at the outset about the summary judgment is that it does not stand alone. Now, in the last video that I made, where I talked about the 12B6, I did place an emphasis on the other issue. I even said, hey, look, there's a spouse, there's a person, and the person says, I have a spouse, and what do? Right? So I just said, hey, look, focus on the spouse, on the status. It might be that they're divorced. I mean, well, if she's married, they can't be divorced. If she's separated, or right, things aren't going well, there's trouble in paradise, whatever, or you might not be interested, you're just having a conversation. But the point is that there's another person, another entity. So the same thing here for the summary judgment. You're looking at a different issue. And why do I emphasize that? Because this could be this is one of these issues that is tricky. It could be a little confusing. But the trick here, all right, I'm just gonna tell you off the bat. The trick to the summary judgment is to analyze the other issue. Now, in this case, Mahonoi versus Levy, what is the other issue? We have a summary judgment. That's one. What's the other issue? What do you guys think? And you might be saying something like, well, it has something to do with free speech, right? It might have something to do with punishing a student, right? The school's punishments. Right? So that's going to be the other issue. You already know it's going to be summary judgment, and what else? Free speech. It's going to be a free speech issue, right? So did I mention Tinker already? So you might be thinking, okay, we might have to apply Tinker here. That might come into play. Okay, let's continue. Okay, introduction. Let's see, now after discovery, and I highlighted that to emphasize what? What I want to emphasize, that for summary judgment, right, you have the opportunity. It kicks in after you have the opportunity to conduct discovery, and that's what they did here. Okay, I'm not gonna get too much into this as far as reading. Let's see now. It says here, it is an open question in the Third Circuit whether a school district may ever punish students for off-campus speech. We know that schools can punish students, right, for their conduct within the school. This is an off-campus act right here. Okay, let's continue here. Again, they touch an out-of-school speech. Let's see now. Let's continue here. Well, let's read this. It says, first, the Third Circuit precedent makes clear that school districts do not have the power to punish students for out-of-school speech because the speech is disrespectful or profane, even if the speech connects to school in some way, right? So, yeah, so there's nothing there that, right, and at the level of the Supreme Court that says that schools have that authority to punish students for out-of-school speech. Okay, so they go on to say here, BL is the name of the student. At the time when she committed this act, she was 14. I think she's now 18. Okay, but let's see now. The district's witnesses have disavowed any explanation that BL's snap would cause disruption. Indeed, the record does not reveal any basis for the district to anticipate substantial material disruption. Why do I highlight that? Because that might be the elements too, right, to Tinker. We'll talk about Tinker in a bit as well. We'll focus on that. And show that, in fact, no substantial material disruption occurred. So they're using the elements of the issue. I focus a lot on elements. You guys will see that because a lot of times people focus on the issue. But to drive the argument, you need to use these elements.
The Supreme Court's decision in Tinker versus Des Moines said students' rights were limited on school grounds to help schools prevent conflicts. But Justice Stephen Breyer did not seem to think that criteria was met in Levy's case.
Did that cause a material and substantial disruption? I don't see much evidence it did. And if swearing off campus did, I mean, my goodness, every school in the country would be doing nothing but punishing.
Accordingly, the district cannot meet the standard announced in Tinker. There it is. Okay, let's keep going now. Let's see now. So again, this is the plaintiff's motion. Factual background. Let's get into this a bit so you can have a thorough understanding. The defendant school district punished plaintiff BL for venting her frustration with life after a particularly difficult week by sharing with her friends a snapshot post that said F school, F softball, F cheer, F everything, superimposed over a photo of her and a friend at a convenience store with their middle fingers raised. Posts on Snapchat are designed to be temporary and ephemeral. What does ephemeral mean? It means temporary. Fancy language. Yeah, you gotta use that, right? Let's see now. Let's keep going here. Let's see now. So she violated the cheerleader rules. She used foul language. Okay. Now the parents made repeated requests because the student was suspended for about a year. They're like, let our child go back, right, to be a cheerleader. Let's keep going here. Argument. So this is the language for the summary judgment. It says here, a movement is entitled to summary judgment if it shows that there it is again, look, these fancy words. There is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Okay, and then they define material, right? I don't want you to focus too much on how material is defined because this is third circuit. You might not practice in the third circuit, right? But again, the fancy language is this. There is no genuine dispute as to any material fact. Okay, so what do you have to do with this language? Again, you analyze the other issue. How do you analyze? And I always talk about my little formula there, E plus B plus F element, right? Substantial, for example, plus because, right? There was substantial disruption because the facts, because the students became agitated and they caused a riot, right? I think that sounds like Tinker. Okay, but the way you analyze this is that, right, is you use the elements and you tie it in with the facts of the other issue, right? How do you analyze summary judgments? You focus on the other issue. You do a thorough analysis. And that's what they're doing here. They said, hey, look, the issue of summary judgment. So how are we going to analyze? We're going to analyze freedom of speech. The other issue, Tinker. Okay, let's keep going now. Okay, I'm going to just skip this, and I think you're feeling me here. I think you're understanding. Okay, there are no applicable exceptions to Tinker. I don't want to go into this. Disruptive. Let's see now. Tinker. Okay. Does not apply to out-of-school speech. Okay, I don't want to. Okay, I already mentioned that. They're just citing case law. Okay, so let's read this. It says BL, the cheerleader, did not mention any person and did not even refer to her school or her team in particular. The snap referred generically to school, softball, cheer, and everything. The snap contained no school uniforms, logos, or insignia associated with the school. Now, this is the motion from the plaintiff. This is not the order, but eventually, I said, goes to the Supreme Court level. The Supreme Court is going to agree with the student, with Levy. Okay, so let's continue here. So here's the black letter law for Tinker. The rule announced in Tinker is that generally public schools may not punish speech unless the speech creates a risk of substantial material disruption to school activities, a high bar. Okay, so they're applying Tinker, they're analyzing Tinker. Okay, the other issue. Okay, let's continue here. Okay, let's see now. So they're saying that the school had no reason to anticipate that the students' snap would be disruptive, and in actuality, it did not cause substantial material disruption. So again, they're using the elements to make a conclusion on the other issue and to determine whether a summary judgment is proper. And let's continue here. Okay, and I think I'm gonna just go to vagueness. I'm not gonna get into that. I think I'm gonna just go to the conclusion here. Let's see now. Conclusion: for the foregoing reasons, plaintiff requests that the court enter summary judgment in plaintiff's favor, and that's exactly what the district court did. And of course, the defendants appealed, and it went all the way to the Supreme Court. Now, let's talk about the application for the bar exam. Let's look at the cheat sheets. And here's what I recommend that you use: the legal and remember again, it's the same thing for the bar exam. Analyze the other issue. The legal standard requires, and this is, let's see now, yeah, this is mostly from Rule 56 FRCP, Federal Rules of Civil Procedure. The legal standard requires the moving parties to demonstrate that there is no genuine issues of material fact when deciding whether to dismiss the case. The court must accept the allegations of the complaint as true. Just kind of like the 12b-6, right? Give the benefit of the doubt to the other party, to the non-moving party. The court must also view the facts in the light most favorable to the non-moving party. That's what it is. And again, these cheat sheets that I have, well, this one is free, so there's a link there at the bottom. So you have to opt in. You can always opt out. But why would you not want to opt in? All right. Okay, so yeah, if you have any questions, just leave a comment here at the bottom. Don't forget to subscribe to my channel. Okay, and also like, because if you like it, then right, YouTube will recommend it. Okay, so I think that's about it. Hope you enjoyed this video. I wish you all the best. Until soon.